I'd like to maybe just address some of the decisions by the Inter-American Commission. There's been a number of decisions that have been filed with the Inter-American Commission by Indigenous groups, and the Agostini decision was the first decision. The Agostini people brought a case against Nicaragua, and that decision really began this process for the Inter-American Commission and the Inter-American Court on Human Rights to consider Indigenous people's rights in the context of human rights. And basically what the Inter-American Commission stated, and as well the Inter-American Court on Human Rights, is that these human rights also apply to Indigenous peoples. And so they stated that the right to property applies to Indigenous peoples. So the human right to property is a right that Indigenous people have. And that states that are part of the, that have signed on to these treaties, and I would argue also under customary law, have an obligation to honor both the treaties and the customary law, but in particular the treaties. So under the Organization of American States, Inter-American Commission on Human Rights have said that according to the American Declaration on the Rights and Duties of Man, that states like Canada have an obligation to implement, effectively implement the right, in particular the right to property, which is the one that the Hulkaminum are most concerned with. In a number of the decisions that they have made, they have stated that it's not enough for states like Canada to simply say, well, you can go to court. And this is really what the Canadian government has said, notwithstanding the fact that Section 35 of the Constitution, the Canadian Constitution, recognizes Aboriginal title. What they've said, first of all, they argued that Aboriginal title doesn't exist. They lost that argument. Now what they say is, well, we don't know where it exists, and you have to go to court and prove where it exists. So you have to go and litigate, and we'll fight you all the way. And we see the experiences of the Gitxsan-Wet'suwet'en and Delgamuukw in the Delgamuukw decision. Millions of dollars were spent to litigate that case, only to be told when they got to the Supreme Court of Canada that they had to go back and start over again. So, you know, what's the effectiveness of that? We see now in the Roger Williams decision with the Tl'ul'thut people, even though the Tl'ul'thut people were able to lead enough evidence to establish title to half of their claim area, the judge in that case said, well, because your pleadings were you said that you were going to establish title to your entire area, I can't issue a declaration. And so again, on a technicality, the Tl'ul'thut people have lost that case. So the Inter-American Commission is saying that it's not enough for states like Canada to say, well, you can go to court and prove it. They're saying that Canada has an obligation to put into place an effective mechanism to recognize and demarcate and title Aboriginal people's lands. And that will become the interesting part of these type of decisions. As Indigenous peoples in Canada begin to use the inter-American and the international legal area to say, Canada, you have some international obligations. One of the international obligations that you have is to recognize title. And you have to do so with a much more effective system than is currently in place. So I think that this demonstrates how the international area and the domestic area can work together. That the international legal system and the domestic legal system can work together towards moving Indigenous people and First Nations people to a point where their rights are in fact going to be recognized by Canada. And that's the hope. The hope is that the Hulkaminum case will help to move that forward, that it will serve as a model for other First Nations to look at as they also strive to move forward rights that are set out, human rights that are set out in the American Declaration on the Rights and Duties of Man. Again, that's not a document that we normally look at when we think of First Nations law. Lawyers are not accustomed to looking at the American Declaration on the Rights and Duties of Man. So hopefully through presentations like this, and as I say, through work by organizations that are defending human rights, that this type of looking at an opportunity to cross-fertilize areas of law, domestic law and international law, and see how they can support each other, and if that will in fact make a difference. So that's the presentation for today. I want to thank you for giving me this opportunity, and hopefully we can carry this dialogue on at a future time. Thank you.
May I thank you, Robert, for helping us understand this much better. I forgot to mention in my introduction that Robert is a lawyer and a member of the BC Law Society, and he has been concerned about the lack of awareness amongst lawyers and others about international human rights, and particularly about the remedies that may be used in both the United Nations and the Inter-American system on human rights. So I want to thank you for helping us understand that. Lawyers' Rights Watch Canada has been quite concerned about the lack of access to effective remedies to determine and protect international human rights here in Canada. Internationally protected human rights that Canada is obliged to implement here in Canada, and in particular the lack of remedies to determine and protect Indigenous people's rights. We've seen this illustration very aptly here today, and we're very honored to be joining you to do an amicus brief in the Inter-American Commission on Human Rights in the Hulkaminam Treaty Group's petition.
Thank you. Maybe just to address the last issue that was raised by Catherine in terms of how these type of decisions would get implemented, I think that will become an important area. We know that the Inter-American Commission can only make recommendations. They don't have the authority to order Canada to do anything, but it really is within the international community where I think the strength of these type of cases will come. We know that for instance, Nelson Mandela said that without the international community, they could not have accomplished what they did in South Africa. So, notwithstanding the fact that this decision would not be a decision that the Inter-American Commission could enforce, contrary to what Canada and British Columbia are saying, we would say that it is binding on this country, that Canada has an obligation to honor their commitments, their international commitments. And if they don't honor those commitments, then certainly it will be an indication of the government's reluctance or a refusal to comply, and will send a message to the rest of the world. So it really is within that area of the opinions of Canadians and the opinions of the world in terms of Canada's position on human rights that will be the enforcement mechanism.
It really is only a strong and well-educated civil society that really begins to insist that governments and states implement international human rights.
That's correct. Thank you.